Well, good afternoon. I'm Niloufer Oral. I have the great privilege and pleasure of being the director of the Center for International Law at the National University of Singapore. And I warmly welcome all of you for joining us today, where we will have the great pleasure and honor to listen to a very dear friend, colleague, and one of the leading experts in international law, Professor Larissa Herik, who is visiting us at CIL as a distinguished global scholar. So we're absolutely delighted to have her. She is, as written here, a professor of international law at the Grotius Center for International Legal Studies at Leiden University, and also a member of the Permanent Court of Arbitration, general editor of the Cambridge Studies in International and Comparative Law, and very interesting, and I know why you couldn't stay longer with us, is a judge, part-time judge at the District Court of The Hague International Crimes Unit. So my dear colleague and friend Larissa has a great deal of experience and knowledge in this area that she's going to be talking about, international criminal law. And I'm not going to take more time other than to say this is an extremely timely issue, crimes against humanity, practically fresh off the press. They just met last week, the General Assembly, and that's all I say. So, dear Larissa, if I may, thank you so much for accepting to speak, and it's a great pleasure. Rashmi is our very dear research fellow at the Center, and she will be moderating this event, also with much experience in international criminal law.
Thank you very much, Niloufer, for this very kind introduction. It's an enormous pleasure for me to be here at Maxwell Chambers for this lecture on a road to a convention on crimes against humanity, and to talk about the steps that are being taken. And I'm really grateful to you all for being here in such large numbers. And I already actually look forward to hearing from you what you think about this convention. But maybe let me kick off first. I'm very grateful also to the Center for International Law, and in particular its director, Dr. Oral, for hosting me as a speaker in this distinguished series, and also for welcoming me as a visiting professor at their center. I must say, it's really wonderful to be part of the Singapore legal and academic scene for such a short period of time. And I must also say that I'm very impressed by the dynamics of the center and its researchers, and mostly also its director, and just also the very wide scope of expertise that is present and that I encountered at the center. I also believe that Singapore has a unique position and responsibility. It has a very strong academic and international legal center presence. It is really a hub for international law, as we could see with the impressive conference last week. And I think we all have a responsibility to uphold international law in these stormy times that we are living. So this lecture on crimes against humanity is very well timed, in the sense that we are having this lecture here in Singapore, while our international law colleagues and delegates from ministries of foreign affairs and other departments of UN member states have gathered in New York at the UN headquarters for their first preparatory meeting for a UN conference on a Crimes Against Humanity Convention. So it was decided by the General Assembly 6th Committee last year, 2022, that there will be 2 preparatory committees, and then there will be negotiations in 2027 and 2028. So it's very well timed for us to speak about that. At the same time, one could also say that this lecture is ill-timed, in the sense that there could be hardly a more complex time to think about or speak about negotiating a new treaty, less still a treaty on such a sensitive issue as international criminal law and specifically crimes against humanity. But ill-timed or well-timed, the fact is that the treaty is being discussed now in New York, so then let's also discuss it here in Singapore. So a convention on crimes against humanity has been very long in the making. Will it come to fruition now with the steps that are being taken in New York? And if negotiations were to produce a treaty, and international law is, after all, the story of the unexpected, what kind of treaty would that then turn out to be? Now, of course, it's very difficult to predict anything these days, in particular anything to do with international relations or international law, and more in particular, perhaps, anything related to international criminal law. So rather than offering you full-fledged answers, what I will do is I will offer you some building blocks to then reflect together on the questions that I just have raised. And particularly, I think I would like to take this moment to reflect on the identity of this possible new Convention on Crimes Against Humanity. So to do so, my lecture is composed of 3 parts. The first one is to reflect briefly on the origins of crimes against humanity. What is this crime about? How does it relate to other crimes that we know, genocide, crimes against humanity, war crimes, aggression? So that's the first part. Then there's the question, when did we in the international community start thinking about a dedicated Convention on Crimes Against Humanity, and why would we need such a convention? And thirdly, the question, of course, is where do we stand today with these negotiations ongoing or about to start? What is going on in New York? What is the baseline for the discussions? What is the context, legal and political? What are the sensitive issues? What are the issues that states do not align on? And where are we heading? That will be the third part of the lecture. So first, let's go to the origins of this concept of crimes against humanity. Where did it all begin? Now, the origins of crimes against humanity as a concept, not so much a legal term, but as a concept, are often traced back to the 19th century and sometimes even to earlier times. But in the 19th century, what we see is that this concept of crimes against humanity was invoked, and broadly speaking, in relation to 2 phenomena. Firstly, the term crimes against humanity was used to denounce the slave trade, particularly the transatlantic slave trade. Secondly, the term was used more or less around the same time to justify military interventions, in particular by Western states, under the banner of humanitarianism, so as an exception to the non-intervention principle. And so what we see right from the start was that there was, on the one hand, a moral use of the term crimes against humanity to denounce crimes against our collective human soul, slave trade, but also a political use of the term as a concept to justify intervention, military intervention or other forms of intervention. And this dichotomy that is inherent maybe in the term is still there. And it is very much, I think, also at the heart of discussions that are now ongoing in New York. Now, while the origins of the concept lie in the 19th century, it was only in the 20th century that this concept became a legal term, that the crimes against humanity became an international crime under international law. And this happened after the Second World War. So the concept of crimes against humanity was catapulted, we can say, into full legal existence when it was included in the statutes of both the Nuremberg as well as the Tokyo Tribunal. When drafting the statutes for these tribunals, and in particular the statute for the Nuremberg Tribunal, it was considered that this crime of crimes against humanity was necessary in addition to war crimes and the crime against peace, as aggression was then called, to capture the full scale of criminality of what had happened. And crimes against humanity was needed as a separate crime, in particular to cover acts of violence that had been committed during the Second World War, but that were not necessarily part of the war and of the hostilities. And these were the acts that were committed by Nazi Germany, in particular against German Jews, their own citizens, who had by the time mostly been stripped of their citizenship, but the laws of war at the time did not cover acts that were committed by a state against its own people. And so these types of crimes, the crimes that we now call the crimes of the Holocaust, they were not covered under crimes of peace or war crimes. So effectively, crimes against humanity was included as a relatively new concept to cover the crimes of the Holocaust. Now, this label of crimes against humanity at the time was preferred over the word or the crime of genocide, which already existed as a word at the time. And the crime of crimes against humanity was preferred because of the legality principle. So this idea that you cannot legislate retroactively. Now, the legality principle is fundamental to any type of criminal law, and this was, of course, also the principle that Judge Paul relied on in his dissent in the context of the Tokyo Tribunal. So it was considered that genocide existed as a word coined by Raphael Lemkin, but only a word and not a legal concept, and so the drafters were hesitant to include it into the statute. Inclusion of crimes against humanity into the statutes of the Nuremberg and the Tokyo Tribunal was justified with a reference to a clause that already existed and that we find in the 1899 and 1907 Hague Conventions. This was the Martens Clause, which referred to the dictates of humanity. And so at least that word, humanity, was already present in a binding treaty. And so the drafters said that there was some legal basis, even though, of course, that was also clearly minimal, to say the least. But the crime of genocide at the time only existed in the writings of one man, Raphael Lemkin, so that was in any event considered insufficient. So what we have is that the concept of genocide existed and the concept of crimes against humanity, and these are two concepts that have great similarity. In fact, these are two crimes that both cover system criminality against civilian populations or against a specific human group. But crimes against humanity featured in the statutes of these post-World War tribunals, and genocide did not. Then afterwards, the tables turned. So what we see after the Second World War is that genocide was included and codified in a separate, dedicated treaty, the Genocide Convention. And that was thanks to the enormous efforts of one man, and I've already mentioned his name, Raphael Lemkin, who was the intellectual father of this concept of crimes against genocide. But no similar initiative was taken to conclude a separate Crimes Against Humanity Convention at the time. Still, even without a treaty, the concept of crimes against humanity stayed around. It was dormant for a while, as the entire area of international criminal law lay dormant after Nuremberg and Tokyo, until the 1990s, when the UN Security Council established two ad hoc tribunals, the Yugoslav Tribunal on the one hand and the Rwanda Tribunal. And then the crime of crimes against humanity again was included into the statutes of these tribunals. And it was included in quite what I call a chameleonic way, a chameleon. And why? Why chameleonic? Because what we see is that the definition of crimes against humanity differed from the statute of one tribunal to the other. So just like a chameleon changes color to match his or her environment, the definition of crimes against humanity, the precise legal technical definition, was adapted all the time to suit the legal and factual environment in which it was going to be applied. And that, of course, is quite odd in a criminal law context. So, like we saw with the Nuremberg and Tokyo tribunals, also here, from a legality perspective, there were some complexities, if we call it like that. Now, eventually, this all culminated in the Rome Statute for the ICC, which was effectively the first international treaty with a legal definition of crimes against humanity. So the definition of crimes against humanity, as we can now find it in the statute of the International Criminal Court, also includes crimes against humanity that are committed outside the context of an armed conflict, outside wartime. And this is something that has been an issue of great contention earlier on. So in the ICC statute, we find now 4 crimes: aggression, which is about starting an illegal war, and the ICC does not have full jurisdiction there. We also find war crimes, which is about individual violations of the laws of war, so that can only be committed in times of war. And then we have the crimes of genocide and crimes against humanity, which as I said, are in a way twin crimes, in the sense that they both are about system criminality, large-scale attacks on a civilian population or on a specific human group. Now, if we already have an international treaty with a definition of crimes against humanity, this ICC statute, why would we need another one? The simple answer is, of course, that not all states are party to the International Criminal Court. And moreover, it is these days an institution that is very heavily under attack. Also, the International Criminal Court is about individual responsibility, whereas the Crimes Against Humanity Convention is about much more. So let's have a look, and then we move to the second part of this lecture. Let's have a look at this question: why do we need a Crimes Against Humanity Convention, and how would that then relate to the existing architecture that we already have? So what are the origins for this discussion, not only about the concept of crimes against humanity, but about a specific treaty on crimes against humanity? Well, legal developments happen because there are people who push for it. A treaty always starts with a person. Of course, ultimately, many persons are needed for new legal development and for treaties. Ultimately, it's very much a collective effort. But there are people that are needed, that push hard at the right time. And those people, I think, must be mentioned. So Raphael Lemkin, I already mentioned him as the father of the Genocide Convention. Without him, we would not have that convention. For crimes against humanity, we do not have the same unique person, but there are a few persons that have been very important. One person that we must mention is Sherif Bassiouni, an Egyptian lawyer and scholar who wrote extensively about crimes against humanity. And another person, we do have mothers in international law. I think we just need to recognize them, so let's do it. Another person is Leila Sadat. She's a US professor who launched the Crimes Against Humanity Initiative in 2008 with a specific goal of drafting a treaty. And I think she has been successful, because that's why now the negotiations are about to start and the preparations is ongoing in New York. So she managed to bring international legal experts together, also here in Singapore in 2016, to prepare the drafting for this treaty for crimes against humanity that could then serve as a model for the negotiations. And then others joined the team. Also important, Sean Murphy. He was the US member of the ILC, so now the US has withdrawn from the International Law Commission, but he was a member of the International Law Commission of the UN, and the International Law Commission is the UN organ that has the task to codify and develop new law and treaties. So he proposed to bring this concept of crimes against humanity on the agenda of the ILC, and the fact that the topic was adopted by the ILC in 2013, I think is quite remarkable, because already then the enthusiasm for international criminal law that was very high in the 1990s and the early 2000s was already in decline. But still the ILC took it on board and they started to work on a draft treaty for crimes against humanity. Now, what is really interesting is that around the same time, a little bit earlier, around the same time that the ILC decided to work on a convention for crimes against humanity, something else happened. In The Hague, a few states convened an expert meeting. This was held, very simple meeting, held outside the structures of any international organization, not the UN or anything else. It was a meeting mostly with prosecutors. Representatives of ministries of justice rather than ministries of foreign affairs. So the Netherlands, Belgium and Slovenia took the lead in organizing this, but 19 states came together. And the lead question for their meeting was, is there a legal gap in the international framework for state cooperation for the prosecution of international crimes? And these experts said, yes, we have a gap. What we have currently in international law is a genocide convention. We have the Geneva Conventions, which are the conventions that are about war crimes and the regulation of war and hostilities during armed conflict. And these conventions, they include some provisions, for instance, on extradition or mutual legal assistance. But these conventions were drafted in 1948, 1949. And so they're only very rudimentary provisions. And if we look at state cooperation these days for criminal law purposes or extradition, we see that we need much more refined provisions. And so these rudimentary provisions that we have are not enough. So for instance, if we talk about hearing witnesses via video conferencing, which can be very important for the preparation of a prosecution of international crimes, obviously, we don't find a legal basis for that in the Genocide Convention of 1948. And for crimes against humanity, there was no convention at all. So you could not ask for the extradition of someone for crimes against humanity. So they said, yes, there is a legal gap. We do not have provisions that allow us to prepare for the prosecution of these international crimes at the domestic level. We just have no legal basis to ask another state to assist us with the preparation for these files. So it was a very practically oriented meeting. And having decided that there was a gap, they said we need to do a follow-up step. And so they decided to create the MLA initiative. And this is MLA, Mutual Legal Assistance Initiative. And again, this was decided outside the structures of the UN or any international organization. So you had then 6 states that joined in a cross-regional alliance. And I think this is a very interesting concept that we need to keep in time for times to come. Cross-regional alliance of those states that come together, believing in international law, trying to uphold it and trying to build it further against the odds maybe sometimes. So these states were Argentina, Belgium, Mongolia, the Netherlands, Senegal and Slovenia. So cross-regional. All the regions were in a way represented. And they started to work on this treaty for international cooperation and extradition for all the international crimes. Genocide, crimes against humanity and war crimes. So we have these 2 initiatives existing at the same time. Now what happens, of course, if initiatives coexist, is that people, we are only human after all, people become a bit competitive. So we had these competitions between, on the one hand, the ILC initiative for Crimes Against Humanity Convention, and on the other hand, the MLA initiative. Even though the competition was not needed, because actually they were very complementary in nature. On the one hand, the MLA initiative was about states' cooperation for all the international crimes, and on the other hand, the Crimes Against Humanity initiative was also about state cooperation, but it was about much more. It was also about obligation to prevent genocide. It was also about a legal basis for dispute settlement to the International Court of Justice. So they had some overlap, but also very different identities. Now, in this competitive / complementary spirit, I think for a long time the people who were more engaged with the ILC initiative, they said, well, you know, this MLA initiative, it will fall behind because it does not have an institutional home. It has to be negotiated in a completely unregulated setting, and that's very difficult for an international treaty. But eventually, this, let's say, homelessness proved to be an advantage for the MLA treaty. Because when the ILC draft was ready, and the ILC presented it to the UN General Assembly, it actually seemed as if this ILC draft came to a deadlock at the UNGA. So the UN General Assembly said, thank you very much for this convention, and they sat on it, and nothing happened. Whereas the MLA initiative was a treaty that was negotiated by a coalition of the willing. And of course, if you try to negotiate a treaty within the UN, you have almost 200 states that need to agree on something. Very complex. If you have a treaty where you just say, if you want to join, you join. If you don't want to join, you don't join. You have a much smaller group, and of course, obviously, it's much easier to negotiate. And so this MLA initiative moved ahead, and ultimately it was adopted in Ljubljana capital of Slovenia, and it is now called the Ljubljana-The Hague Convention, and it was signed into being in a formal ceremony in The Hague in February 2024. So we have 40 states that signed that treaty so far. Now, interestingly, coincidentally or not, later that year in 2024, the Sixth Committee, the UN General Assembly, decided to then also push the Crimes Against Humanity Convention forward. And I think there are a number of states like Mexico and other states that have been very instrumental in pushing the treaty forward. I think also Singapore played a very important role here, and I want to mention that explicitly because I think Singapore will have to keep playing that role. And as I said, it is much more difficult to negotiate a treaty within the UN with all the states of the UN, with all the different interests, than it is for a treaty to be negotiated with 40 states of like-minded nature only. But still, you could of course ask, okay, but now we already have the ICC statute, we already have the Ljubljana-The Hague Convention. Do we really need another treaty on crimes against humanity? I think it's a fair question, and I'll give you a fair answer, and that is yes. Yes. Two simple reasons. Firstly, there are still issues that are not covered by the treaties that already exist. And secondly, there are many states that are not party to these treaties that exist. Some states are actually even very adverse to the ICC, maybe for different reasons. And as I said, this Ljubljana-The Hague Convention only has 14 states, so that's not that much. Most importantly, as I said, there are still open questions that are not regulated in international law. And the most important questions relating to crimes against humanity that are still in need for an answer and regulations in a treaty are questions that do not concern international criminal law proper, that do not concern the prosecution of individuals. They are questions, broader questions, maybe more important questions. They are questions about, is there an obligation to prevent crime against humanity, and if so, what is the contents of that obligation? What about the responsibility of states for crimes against humanity? What about bringing cases to the International Court of Justice when there is a claim or a perception that crimes against humanity are being committed? The existing treaties do not provide for that. But these questions, obviously, are also amongst the most sensitive ones. So it's very clear that the negotiations for a new Crimes Against Humanity Convention are going to be very complex. So what I would then like to do in this third final part is to speak about these negotiations that we are having in front of us. So what is the road towards a convention on crimes against humanity? Where are we now? What is the context? And also what are the most sensitive issues where states are not on one line when we talk about this convention? Now, already in the run-up to this preparatory meeting that states are now having in New York, it was very clear how difficult and complex and sensitive the issues around crimes against humanity are. Because the first question was, okay, what is our baseline? Do we use the crimes against humanity draft of the ILC, or do we use something else, just as a starting point for discussion? And already there we can see that states had different views, because of course the text that you use as your starting point already pushes you very much into a certain direction. Another issue that was a point of discussion even before states started to talk with each other was, what about civil society? To what extent do we welcome civil society as a serious partner in these preparations and negotiations? And there also you can see that states had very different views about welcoming civil society, and if so, then which civil society precisely. And so I think these two examples go to show that every single thing about this convention will be complex. But let me zoom in on three issues where we can see that there are different viewpoints, and also give you some background about the different positions of states. The first issue that will lead to discussion is the definition. What is the definition of crimes against humanity? Now what we see is that in the International Law Commission, what they did is that they copy-pasted the definition from the ICC statute. The only thing that they left out was the definition of gender, because that was hugely controversial in the ICC context, and so they left that out. Otherwise, they copy-pasted it, just like this other treaty, the Ljubljana The Hague Convention, they also did that. They just copy-pasted the definition. I think we're all lawyers. We probably, our first position maybe to like that, because generally as lawyers we tend to like coherence, we like consistency. But I tell you, states hold quite different positions on this. Yes, on the one hand, there are many states that are in favor of keeping the definition in line with these other treaties, so that we do not have different definitions in different treaties. So they refer to the importance of coherence in an international legal system, and having different treaties with the same definition contributes to that. States that want to keep the definition as it is, they also say that opening the definition up would be opening up a can of worms, the Pandora's box argument. And so they say, let's take the examples of the drafters of the ICC statute. Then they were talking about genocide, the definition of genocide, that many states also, indeed scholars say, it's awkward, it's a bit limited, it's a bit biased, why do you protect certain groups, not others? So let's revisit the definition of genocide. And when they were discussing that in Rome, when they were drafting the ICC statute, the agreement was, let's not do it, because it's just too complicated. We will never agree. So this Pandora box argument is being put out there now again by states wanting to keep the definition as it is. The last argument that states that want to keep the definition as it is put forward is that they say the definition as it is already really quite broad. This is about any attack that is large scale or widespread against the civilian population. Then there are different acts, murder, extermination, also gendered acts. So let's just keep it as it is. It is broad enough. So this is one group of states. Then there are also states that do wish to deviate, that do say, look, this is now a generic convention about crimes against humanity. We must seize this opportunity to really make sure that crimes against humanity captures all the criminal behavior that we want to criminalize. So these states who want to deviate, actually, we can subdivide them in two groups. There is one group of states, and those are in particular states that are not a party to the ICC statute, who say, look, we are not a party to the ICC statute, we didn't necessarily negotiate the ICC statute, why would we now, by just copy-pasting the definition, suddenly be bound to a definition that we did not participate in negotiating? These states generally also want to limit the definition, to go back. One way to limit the definition is to say crimes against humanity can only be committed during times of armed conflict. If you include that element, you of course clearly, very seriously limit the scope of crimes against humanity. Some of these states that want to limit definition also say, okay, we agree to this broader notion of crimes against humanity, but we want to take out specific acts, such as torture and forced disappearance or apartheid. We don't want these acts to feature into the list of acts that can make up crimes against humanity. And these states, I will not go and name states, but I can say that they are quite regionally varied. So it is just not that they come from one block or one region of the globe. Now, another way to deviate is not to limit, but to broaden the definition. So this is actually quite the opposite. And broadening the convention would mean to add new acts that are also criminal, that can also amount to a crime against humanity. So there are many, many proposals. States say, for instance, ecocide should also be a specific crime against humanity, looking at what is happening with environmental destruction. Forced marriage gender apartheid, slave trade, this is in particular the African states very much pushing for this, starvation, but the list is longer, colonialism as a crime against humanity, illegal exploitation of pillage and natural resources, serious violation against children, crimes committed by terrorists, crimes committed against occupied people in the struggle for self-determination, unilateral coercive measures or sanctions as a crime against humanity. And it goes on and on. So we can really see that there are many different acts that are being proposed, and under that there are many different ideas of what crimes against humanity is about. So this is one of the points of discussion, and it's a very fundamental point, because it's about the identity of the treaty. What is crimes against humanity about? Is it about physical attacks against the population, or is it also about sanctions or much other kinds of acts? Is it about acts committed by states or acts committed by terrorists? So what are we talking about when we're talking about crimes against humanity? Very fundamental. And to what extent do we want to stick to the ICC, or do we want to move beyond the ICC or correct the ICC? So that is one point, and I will just leave it there. A second point where states have different views is about the obligation to prevent. So, well, let me caveat this. There's much disagreement about the definition, as I just said. There's actually not so much disagreement about one thing, and that is the title of the convention. So the title of the convention will be Convention on the Prevention and Punishment of Crimes Against Humanity. And that is quite similar to the full name of the Genocide Convention. Now, if you say that title in full, which is not so often done, then we realize that the convention is not only about punishing people, it is also about preventing. Most of the provisions of the Crimes Against Humanity Convention are about punishment, like with the Genocide Convention. But is that then also the most important objective of this convention? And there is this US scholar, he once wrote on this issue, if life is the most precious of things, should not acting before the fact, as opposed to punish after the fact, be the primary technique of international lawmaking and international law to deal with mass murder? So should the obligation to prevent actually not be the most crucial one for a credible convention on crimes against humanity, which is underscored by the fact that it is the opening provision in the Genocide Convention, Article 1. And why is there disagreement about this? What is the problem? If we speak about it like this, we would all tend to agree that preventing crimes against humanity should be very important. So it is still a controversial provision to some extent. Let's have a look at the parallel provision of the Genocide Convention to find out what this provision is about and why it would be controversial. So the obligation to prevent genocide is laid down in Article 1 of the Genocide Convention, and it says states undertake to prevent genocide as an international crime. For very long, it was thought that this is some kind of hortatory language, normatively anti, more like a lofty promise and not a legally binding obligation, until the International Court of Justice in 2007 decided otherwise. So the court held in 2007 that the obligation to prevent genocide is actually binding, and the court also said it's binding on all states. So if there is a risk of genocide, all states have the obligation to do what they can to prevent that genocide. They have to use their full capacity. Now this provision is also the provision that is being litigated now in The Hague by the International Court of Justice, for instance, in the case that was brought by South Africa against Israel. And South Africa said, look, we are bringing this case as a way to implement our obligation to prevent genocide. We do what we can to stop it. So when negotiating now a Crimes Against Humanity Convention, states may be wary about this idea of having an obligation to prevent that is very similar to Article 1. They might have agreed to a lofty promise, but they may not necessarily agree to a legally binding provision that can be litigated. So should states be that wary of litigation? I don't necessarily think so. We have litigation ongoing with the case of South Africa versus Israel, and there's also another case that Nicaragua brought against Germany. But what we see in that case is that the ICJ did not impose provisional measures on Nicaragua. So the court was not that intrusive. Now, this obligation to prevent, we see that also in many domestic jurisdictions, cases has been brought to domestic courts, making the argument that governments have an obligation to prevent genocide in Gaza. Let's go to my own jurisdiction, the Netherlands. In the Netherlands, we have had a number of cases that were brought by civil society, by NGOs, asking the Dutch court to order the Dutch government to seize the export of F-35 parts. So we are a big part of this big alliance on the F-35, and they're important hubs in the Netherlands. And cases were brought to order the Dutch government to stop this as part of their obligation to prevent genocide that we have committed to in the Genocide Convention. Now, of course, the extent to which NGOs can bring these types of cases will very much depend on your domestic jurisdiction. The extent to which NGOs can invoke directly international treaties before a domestic court also depends very much of your jurisdiction. And if we look at these Dutch cases, what we see is that actually there was another treaty, the Arms Trade Treaty, that was the most important treaty for these cases, because the Arms Trade Treaty includes very specific obligations not to engage in arms trade during armed conflict. So in the Netherlands, what we see, and we see that also in domestic courts, is that courts were actually quite reserved, and they very much respected the foreign policy domain of the government. And so including an obligation to prevent does not necessarily mean that Dutch or domestic courts will step in. So in my view, I think that it is very important to have an obligation to prevent, and I don't think that necessarily states need to be wary that somehow they will limit their own foreign policy domain on this. But to have a credible convention on crimes against humanity without an obligation to prevent, I think takes away the core of the identity of that treaty. Now I want to say a very last point, and this is also going to be a little bit of a legal technical point, but behind that I think there's a broader identity question, and that is about the dispute settlement clause. So another reason that states might be a bit reluctant to engage in this crimes against humanity convention is that we see now that a lot of states use these conventions to bring other states before international courts in The Hague. And many states that signed up to the Genocide Convention never thought that this would mean that they ultimately would be brought before the court in The Hague. Now states know that there is this risk. So of course, from a state perspective, they may be a bit reserved to agree to these new treaties. If you think about it, it's actually a wonder that states have committed to so many human rights treaties and limited from a state perspective. From a human rights perspective, it is of course a very good thing, but from a state perspective, there's a question, why do states do that? And I think this question becomes more pertinent today. That is, of course, also why there will be a reservation to these treaties, so you can become a party to the Crimes Against Humanity Convention and say, but I don't want to be brought before court. But I think there are still states, and this is also why it's so important that civil society comes in, that do believe in a robust Crimes Against Humanity Convention. And there I think what will be very important is to have a dispute settlement clause that allows states to bring forward a great variety of different kinds of cases. And I want to just make one example, and that is a case that Ukraine brought against Russia. And so just after the large-scale invasion by Russia, Ukraine brought a case based on the Genocide Convention, and it asked the court to declare that it was not committing genocide. Very strange, very strange. Because they said, look, Russia invaded, and one of their arguments was that we were committing genocide against the Russian minority in the East. And so we want you, the court, to say that we are not committing genocide. And everyone was a little bit, can you do that? That is, of course, normally you go to the court to ask the court that the other one did something, not that you did not something. So can you have these kind of declarative judgments? I think it is very important in the world that we are heading into that we have a dispute settlement clause that allows for these types of declaratory judgments also to be made. And so if we see you have this word fulfillment, that is the word that Ukraine used to bring its very innovative case. So words matter, and I think it is important to have a broad dispute settlement clause that allows states to bring cases that we don't think of today, but that in any case allows states to bring cases of this declaratory nature. And we see already here that we are moving into a world where states say, look, I need to protect this or that, and they use that as some kind of intervention to go somewhere. So they say, I need to protect this state from crimes against humanity. We see crimes against humanity diplomacy, as they sometimes call it, states making these allegations. And so we can also see that states have an interest in the International Court of Justice saying, I am not committing crimes against humanity or genocide. So I think that is another point where we need to make sure that we provide a legal basis for new types of cases. Now, to conclude, I've just mentioned a few issues. There are many more controversial issues: immunity, amnesty. They're legal technical issues, but there are deeper questions about this identity of the convention. What kind of convention do we want? Do we want a convention that complements the architecture of the ICC? Or do we want a convention that disrupts it or that corrects it? And of course, that is the discussion that is underlying the discussion about the definition. Do we want to have a definition that also includes new criminal acts, such as slave trade? And the deeper question here is, to what extent should this new Crimes Against Humanity Convention also provide a moral or a legal basis for historic injustice? Do we want to have a Crimes Against Humanity Convention that is mostly concerned with state cooperation, so more transactional, more at the service of states? Or do we also want to have a treaty that is very strong on this question of obligation to prevent, state responsibility, dispute settlement before the ICJ? Do we want to have a convention that informs foreign policy with a broad, robust, specific obligation to prevent? Or is that revisiting this interventionist roots of crimes against humanity? Because the obligation to prevent, of course, can play out in two ways. It can also be an invitation for states to intervene. What kind of convention do we want? And do we want a convention ultimately that is negotiated within the UN, knowing that that also means that we might need to make compromises? Or are we going to say at some point, no, we will go with the coalition of the willing, or the middle powers, as we now call it, and we will go outside the UN to make sure that we have a credible treaty? So there are a lot of policy choices. As I said, we have to see how this all goes forward. I do think that there are certain states that are very clearly aware about the need and the importance of international law, that have a crucial role to play here, like Singapore. So to really conclude, by its topic and by its subject, crimes against humanity is highly political and sensitive. In addition to that, the times to negotiate a treaty on such a sensitive issue could not have been more complex. Like you, I also ask this question: does it make sense to continue to believe in international law in the world that we are now in, to continue to try to advance it? Can we hope for a just future? And the easy answer, of course, is no. but the more inspiring answer that I take from Václav Havel, the Czech dissident, later president. He wrote this: hope is definitely not the same as optimism. Hope is not the conviction that something will turn out well. It is the certainty that something makes sense, regardless of how it turns out. And I think that the Crimes Against Humanity Convention makes sense.